matter of John C. McBride.
I was just going to move it up against the table. Okay, thanks. Thank you.
Mr. Butters?
Yes, Your Honor. May it please the Court, my name is Thomas Butters. I represent John McBride. I'm very accustomed to sitting on the left-hand side of the podium, and because of that, I'm very mindful of the long-standing rule of jurisprudence that when factual issues are decided by the tribunal and they're based upon substantial evidence, the defendant or the respondent, as the case may be, has to live with those findings. And in this case, the same is true of Bar Counsel and the BBO, because this case included 11 days of testimony. It included over 100 exhibits, and as the Court knows from looking at the paperwork, the hearing committee deliberated for a year and a half.
Okay, there was a lot of delay, but I have a couple of questions. First of all, what was ever done with the complaint against Felix? I mean, Felix was deprived of his liberty, which to me is a lot more important than a few $1,000s. And it doesn't seem to me that anybody ever made a big deal about that. Was there any finding by anyone except that he eventually, well, what was the finding in regard to Mr. Felix?
Well, the hearing committee and everyone else found that Mr. McBride neglected Mr. Felix.
Right. And then was that just the end of it?
That was the end of it.
Yeah, that's what I don't quite understand.
Well, it's funny because I was reading that, as you would expect, about that in preparation for the hearing, and to me, the single most important thing about the Felix case is if you read the October 6, 1998 colloquy between the court in New Hampshire, which included Mr. Felix, pro se, and the assistant district attorney, or state's attorney, they called him in New Hampshire. Mr. Felix was not paroled because of anything that Mr. McBride did or didn't do. Mr. Felix said that he should be paroled because the court in the first sentence that he served said, if you engage in meaningful drug rehabilitation, then I think the imposition of the second sentence that I've given you that's consecutive should be suspended. And what Mr. Felix attempted to do in the years that he was trying to get out, which was 2 years, most of which were before, some of which were before Mr. McBride was retained, was he was trying to demonstrate to the court that he had, in fact, participated in meaningful drug rehabilitation. But the hearing clearly shows in October of '98 that he had not completed any substantial drug rehabilitation, and he was paroled simply because he had done 2 years on the sentence, and the assistant state's attorney did not object. So there,
and he had done the 2 years as of October, and he wouldn't have done the 2 years as of May.
Well, that's reaching a conclusion that we'll never know what the judge would have done in May.
Okay.
Because the judge clearly did what he did in October because he had served 2 years and 2 months. And it wasn't anything about, oh, somebody didn't get the records, because all the records were in front of the court at that time. So there were, what I'm saying is there was nothing that Mr. McBride's neglect, and we know the reasons for it in the brief. I mean, he was called to trial before Judge McDaniel in a first-degree murder case, and he tried to postpone it. And the judge just got fed up in New Hampshire and said, look, I'm going to let you out because you've served 2 years. The assistant state's attorney doesn't object, and I'm going to parole you. And then he was paroled to a
And we
detainee.
don't know what would have happened had that case come up in May.
No.
Had that hearing come up.
No, and there's no proof one way or the other what would have happened. None.
So there's no finding of neglect on his part?
No, the court did find that Mr. McBride neglected or I should say the hearing committee, neglected Felix because he was supposed to be at the hearing in October. There were no further continuances. and
What if he didn't,
was-
I mean, what is a lawyer supposed to do in those in that
Well,
situation?
what Mr. McBride
He should have gone to
did-
New Hampshire and not gone to the trial in Massachusetts.
He was ordered to be on trial in a first-degree murder case in front of Judge McDaniel.
Well, he should have done something, don't you think, a
He
few
did.
days ahead of time? Not
Well,
wait
no,
until
but he
day
got the
before.
call, the testimony at the trial was, he got the call from Mr. Bruno, who was Judge McDaniel's clerk for a long time, saying, the judge wants you over here tomorrow morning, ready to roll. And McBride told him, you know, I have something in New Hampshire. And he said, well, too bad. You know, do whatever you have to do. And what Mr. McBride did is he had both of his associates, he tried to get them to cover. They couldn't because they were too busy, which of course was one of Mr. McBride's overarching problems here that you can see. And so they called the court, and the court just said, we're not going to wait. And if you read, I ask you to read the transcript, because the court clearly didn't take any action, or nothing was done as a result of what Mr. McBride did or didn't do.
It was not factored in.
No. No, it wasn't. But what I was going to say was that the hearing committee really did deliberate for a long time and really understood the evidence, and the findings that they made that are crucial to their recommendation of a sanction were that in the Stallworth case, Mr. McBride negligently misused his client funds.
Well,
There
let
was
me ask
one
you-
day.
Let me ask you about the fact pattern in that case. Am I right that both sides agree that the forfeiture case was settled on the 20th, December 20th? That McBride puts...
Well, it was on or about that date.
Okay. Well, the date's important. McBride puts a third of the money into his own account and forwards his two-thirds to the client, and then meets with the parents and then makes a fee agreement on the 23rd. Is that, have I got the facts right?
No, Your Honor.
Okay, what's wrong?
Well, I would submit that the single most important document with regard to the timing is what was Exhibit 17, which is also in the appendix, which is at 192, page 192 of the appendix, finding number. This is a letter that Mr. McBride wrote to the Stallworth, the parents,
Right.
on December 20.
Saying that...
The funds were taken on the 22nd, and he said the case has been
Right.
settled.
And the letter on the 20th says we have a fee agreement.
It's
We have a
done.
forfeiture agreement.
And
Right.
it sets
Done.
forth the agreement, and it does everything.
Right.
And again, I'm not saying that that was right, but in Mr. McBride's mind, on the 20th, and on the 16th, he had notified or attempted to notify Aubrey Stallworth, Jr. But the thing you have to realize is that Mr. McBride always dealt with the Stallworths, Sr. about the money.
Who was the client?
The client was Jr. But again, he was in jail the entire time. He was held without bail because it was such a serious case. And Mr. McBride always dealt with the parents. They paid him in 4 or 5 different increments to do the trial. And it was only natural when the forfeiture case came that he had to talk to somebody, and Mr. McBride said that he talked to them. And you see the evidence, the December 20 letter, which preceded the December 23 meeting, at which they agreed one day after Mr. McBride took the money. There's no question that he got ahead of himself. But one of the things that the hearing committee did, and they did this exactly right, is they understood that no rational person would have ever not agreed to the settlement with the district attorney. Mr. McBride hit a grand slam home run in the bottom of the 9th by shoving the 9th Circuit case regarding forfeiture as being a penalty and therefore implicating double jeopardy down the district attorney's throat. And it was a stroke of genius that resulted in $50,000 of the $175,000 that was seized going back to the client, which was ultimately used for his daughter's education. So there was no rational person would have said no, and Mr. McBride knew that, and he went ahead and deposited the money and took his fee, which was fully disclosed in the December 20 letter, so that when they came in on the 23rd, I think Mr. McBride had every reason to think that they knew what was going on. They approved it. And these were people who had dealt with him all along. Aubrey Stallworth Jr., for example, was he was an educated man. He participated in his defense. You'll see from the record that Mr. McBride, once the motion to suppress was lost, had a 10-year deal on the table. He refused to take it because he listened to his father and decided he was just going to go to trial with no defense. And then the instant that Mr. Stallworth complained, Aubrey Stallworth Jr., Mr. McBride went to see him on January 5th, and they talked about it, and Mr. McBride, at the request of Stallworth Jr., reduced his fee from $15,000 for the appeal to $5,000, gave all the jewelry, which is worth $30,000 or $40,000. That's an exhibit as well to the January 5th letter that Mr. McBride wrote. And then later, several weeks later, when Mr. Stallworth Jr. fired McBride, McBride said fine. He sent him another accounting saying, here's, I have kept $1,000 for what I did. Here's all the rest of the money. I'll put the money in this particular fund for your daughter. I'll get you new counsel appointed by the court. And the same happened in the Von Wood case. Well,
you admit as to the Von Wood case, when I read your brief, you say he just erred in taking the first $50,000 as his fee.
Well,
That's a
in
quote.
retrospect, that's easy for us to say, but you have to remember the agreement he made with Bleck was that he was going to be paid in less than a year. And as Mr. Todd has already said, it was commonplace.
Yeah, but that's
No,
not
no,
what the
but you
terms
said
of this
in your,
agreement says.
you said, I'm quoting your brief, you said in your brief he just erred in taking the first $50,000 as his fee.
I agree.
So
Based
you
on
are
what
admitting that he...
Yes, because based on what the fee agreement said, which,
yeah.
by the way, wasn't drafted by McBride.
No, of course
as
not,
you know.
because the other attorney came with the fee agreements having been negotiated.
Exactly. And again, that was another situation, and you saw some of this sloppy drafting that was done in the letters that related to Stallworth, although the one that McBride himself drafted on December 20, Exhibit 17, is not sloppy. But in the Von Wood matter, McBride tried the case, got a great result, reached a settlement agreement that made a lot of sense, and then said to John Doe, the respondent, you deal with it. The testimony was that McBride had never talked to any of the clients, any of them, except when he was at the trial down in Florida, and that he just kept saying, you deal with it, which again, we've conceded was one of Mr. McBride's problems. He was too busy, and he had associates that were inexperienced, and he gave them way too much responsibility, and he had them do things that they shouldn't have been doing, and he didn't take the time to do what he should have done.
Well,
That's
that can be
very
very-
clear, but he had never had any intent.
But that can be very harmful to clients.
Of course it can. But in this case, it wasn't, because everybody got paid what they were supposed to get paid. Mr. McBride and the findings that were
But if
so
Mr.
crucial.
Von Wood hadn't complained, who knows?
If what?
If Mr. Von Wood hadn't complained to Bar Council, who knows what would have happened?
Well, what would have happened if he hadn't complained is that Mr. McBride would have been paid $15,000 to do an appeal, and he would have gotten a fee of...
Oh, no, I was talking about the second case. I'm sorry.
Von Wood.
Von Wood I'm talking about.
Well, in Von Wood, 19 of the 20 brokers, or 17 I heard, agreed that Mr. McBride could take the first $50,000. Every single one of them, except Von Wood, and that's because he wasn't able to be reached by the associate. And when he was reached, he said, no way, I'm not going to do that. But McBride reasonably, and the finding of fact was made by the hearing committee, he reasonably believed that he had a right to that money. And as Mr. Todd said, that's been the practice in this Commonwealth, and I understand that this particular fee agreement didn't allow that. But again, McBride didn't focus on that, didn't take the time, took the money, and which he shouldn't have, but he never had any intention in any of these cases of doing anything but his very best.
But the client was temporarily deprived of the use of the money.
Yes. Yes. And that's why the hearing committee gave him a 3-year suspension. because it was serious. But he's been a great lawyer in this Commonwealth for 30 years, and he was punished adequately for what the hearing committee found to be his intent, which is the absolute most critical issue for this court. What was McBride's intent? Was it to steal money from people? Was it to commit felonies? No. It was to do the best job that he could, and he rushed around and he handled this in an inappropriate way, for which 3 years is a long time not to practice law when it's something that you've done very well for 30 years and have the kind of reputation that he has.
What are you seeking here?
I'm seeking the imposition of the penalty that the hearing committee gave, which is 3 years, or something less. He's already been suspended for a year and a half. And I would ask that the court either give him 2 years or 3 years, but certainly not disbarment, when all he did was his best for these people.
Thank you, Mr. Butters. Mr. Geller?
Good morning again. I would suggest that what Mr. McBride tried to do in these cases was to get money in his own pocket as quickly as possible without particular concern for the well-being of his clients.
Let me ask you about that December 20th, 1994 letter to the Stallworths, in which McBride stated, quote, "We have entered into an agreement with the district attorney for return of $50,000 and the return of all the jewelry." Now, that doesn't appear to me to be an effort to hide anything about the forfeiture.
I would agree, except for the fact that Mr. and Mrs. Stallworth were not the interveners in that forfeiture case. Aubrey Stallworth Jr. was the client. He was the intervener. It was his money. He's the only one who could have consented to that.
All right, even
to that
accepting
agreement.
that, it doesn't seem to be an effort to hide anything from Aubrey Stallworth, because the reasonable implication is that, or the reasonable inference is that the parents are in some sort of contact with their son. I
agree. Mr. McBride, in fact, wrote a letter to Aubrey Stallworth on the Friday before he wrote that December 20th letter. Mr. Aubrey Stallworth Jr. did not receive that because he was transferred to another institution and didn't receive it. However, that letter said, "Call me. The district attorney is willing to make a settlement offer. Call me, let's discuss
He never
it."
gets a call, which isn't too unusual when the guy is incarcerated. A lot of things can go wrong, including moving, not getting a letter.
He had no
doesn't get
right
the
then
call,
to settle that case without the client's approval.
even though he might lose a very good deal.
He had no right to settle the case without the client's approval. The client had not given him general authority to settle or specific authority to settle. The client may have felt that he had a good case and could have gotten more money for it. This is something that Mr. McBride did unilaterally.
When did the client first raise this as a major problem?
The client, I believe, raised this as this particular aspect of the problem, perhaps a year and a half later when he filed a 93A claim against Mr. McBride.
So a year and a half after he gets this settlement, he and Mr. McBride renegotiate some fees with respect to both the settlement and ongoing appellate litigation. A year and a half later, he decides that, wow, this was settled without my consent, and I need to file a complaint right away.
I can't explain what caused Mr. Stallworth to, at that point, file a complaint against Mr. McBride.
You don't think it has anything to do with his 93A action or anything like that? No personal, commercial, or other incentive that might
the bar complaint, I'm sorry, Your Honor. The bar complaint and the 93A complaint or letter sent to Mr. McBride were done approximately the same time. However, let me just say that Mr. McBride took a fee of 1/3 of the amount that he recovered back in this forfeiture case. This was not a contingent fee. There was no fee agreement between Mr. McBride and Mr. Stallworth. This was Mr. McBride taking a fee of 1/3, which he set, again, unilaterally, after the fact.
Was there any evidence about the reasonableness of the fee?
Yes, the hearing committee found that it was not reasonable.
Well,
Mr.
the evidence was his own expert.
His own expert said that it was not a reasonable fee, given the amount of work that he did and given the fact that he had already gotten the money at the time he set the fee. Absolutely.
I know, but that's not very compelling to me. I mean, that's like saying, well, he didn't have a fee agreement, therefore he shouldn't get paid.
No, nobody's saying assume that the client later ratified the settlement.
Right.
The fee should have been reasonable given the amount of work that was involved in it, given the fact that Mr. McBride knew at the time that he set this $15,000 fee, or actually it was $16,666 fee, that he had already gotten the money in his pocket. So he took that $16,000. He took another $13,500 for a fee, which again he unilaterally set for representing the client on an appeal. Without the client's consent. This was the client's money.
But
he
how
put
should-
it in his pocket, he spent it before the client had an opportunity to object.
How should lawyers decide what kind of a fee to charge in these cases? If you accomplish a brilliant result, even if you only spend 2 minutes making a phone call.
Because the proper course is, in advance of settling the case, you have a fee agreement with your client. It can be a contingent fee. If so, it has to be in writing. There was no written fee agreement in this case.
And there was no hourly fee or
There was
low
no hourly fee. There was
or-
no discussion of fees with respect to the forfeiture case. That was something that when they initially met, there was only they only set a fee on the criminal representation.
Is there a standard fee, a typical fee in these kinds of cases?
The testimony was that oftentimes these cases are handled on a contingent fee basis.
And the contingency would be 1/3?
Oftentimes, yes. I don't know that there's necessarily a standard, but
And that's
the
for very
testimony.
little work. That's a very little work.
It depends. Sometimes there's a lot of work in them, just like any other contingent fee case. Sometimes lawyers get a
I've done
windfall, and
forfeiture
sometimes they
cases.
don't.
I've done forfeiture cases. There's not much work involved in them. So a 1/3 fee is a pretty big fee if somebody
It is a pretty big fee, but this was not a standard contingent fee because it was set after the money had already been recovered. The fact of the matter is that once Mr. McBride met with
Well,
the...
can we stay with that for a minute?
Sure.
Then, are you saying Mr. McBride should not have represented him in the forfeiture matter unless and until there was a fee agreement?
If there was no written contingent fee in advance, the proper course of action should have been for Mr. McBride to sit down with the client and have the two of them agree on a
And
reasonable
until
fee.
there was an agreement, he should not have represented him.
Until there was a fee agreement, he should not have taken any of that money and put it in his pocket and spent it.
But,
I'm not saying he shouldn't have represented him.
okay.
Well, I understood, and maybe I've got the facts wrong, but I understood that the hearing committee had found that the Stallworths Senior had retained Mr. McBride to represent them in the forfeiture proceedings.
There's a separate federal forfeiture case regarding the two automobiles that
Okay,
belonged to
okay,
the Stallworths.
okay.
That's what they had had retained Mr. McBride to represent them on. That case, he neglected. They lost their automobiles because of that neglect, so that there was harm there.
Why was there a 1.5-year delay here between in the issuance of the hearing committee report?
I cannot tell you that. This was a long case. The hearing committee were all practicing lawyers. They have a busy practice. I'm sure that they did the best that they could.
Can it be viewed as ratification? A 1.5-year delay?
Are we talking,
I'm sorry, you're talking about the hearing committee report?
Oh, I'm sorry. No, I was talking, I'll ask my question later. I'm sorry.
Okay. So Mr. McBride argues in his brief that Bar Council somehow delayed the filing of the petition for discipline against him. That's clearly not the case. We were investigating not only the Von Wood matter and the Felix matter, which came in after Mr. Stallworth's complaint, but the record shows that there were additional, some 6 or 7 additional other cases that were being investigated at the same time. We chose which cases we felt were provable, and we filed a petition based on
Was it
those.
appropriate here for the single justice to and for the board, actually, to substitute evidence, well, is to make findings that were different from the findings that were originally made?
I think that they made a different conclusion of law.
I'm sorry, yes.
With respect to
Right.
whether the conduct of Mr. McBride constituted an improper taking of money that belonged to the clients. And yes, that was perfectly proper. They do that on a regular basis. The hearing committee's job is primarily to make findings of fact. It's the responsibility of the board to make conclusions of law and a recommendation to this court. That's what the board exercised its responsibilities properly in this respect.
Mr. Geller, I don't want to nitpick the facts here, but I've just gone back to the single justice's memorandum of decision, and she starts off describing count 1 based on the findings of the hearing committee, and says that it arises from McBride's representation of Junior, the store's Junior, and his parents in the forfeiture proceedings arising from or resulting from the son's arrest, and then she goes on to talk about a separate federal forfeiture action.
What happened, Your Honor, is that when at or shortly after the time that Stalwart Jr. was arrested, at the time of his arrest, they not only seized property from the house, they also seized 2 cars. The federal government came in after the fact and instituted a separate forfeiture proceeding against the cars. Those cars were removed from the state forfeiture action, and Mr. McBride represented the parents in the federal forfeiture case.
That may be correct, but there seems to be some confusion, at least in the facts as recited by the single justice, because it all is talking about the jewelry and the cash and the everything else. It's treating this. That
all belonged to Aubrey Stalwart Jr. He was the only intervener in the state action. So the parents really, they were not parties at all and had no interest in the state forfeiture proceeding.
And when were those forfeiture proceedings commenced?
They were commenced, I don't remember. I know it's in the record. I think several years earlier, at the time of the arrest. And then they lay dormant. The federal ones were within 6 months of the state forfeiture proceeding beginning.
We'll have to go through and sort it out.
On the issue of the sanction, the cases that are cited by respondent, the respondent cites cases indicating that the sanction here is disparate from other sanctions. How do you respond to that?
Well, I think that there's no question but that's not the case. For misappropriation of client funds, by taking funds before you have a right to them, whether you call it fees or premature fees, if you have no right to those funds, that is a misappropriation. The sanction for misappropriation has been since 1984 indefinite suspension or
Respondent says that most of the
disbarment.
cases involved with a 3-year suspension involve the respondent having been convicted of a crime.
Mr. McBride wasn't convicted of. This is not a conviction case.
No, but Mr. McBride says that in cases where 3-year suspensions, I'm sorry, that here there hasn't been a conviction of a crime. In the cases that you cite, there had been convictions of crime.
Absolutely not true. The cases that we cite are the chauffeur cases and the line of cases dealing with intentional misappropriation of client funds with actual deprivation resulting.
Is there any distinction between misappropriation where the lawyer is asserting a claim of a right to a fee, as opposed to an insurance proceed check coming in and the lawyer takes the whole thing?
Or IOLTA funds?
Or IOLTA funds?
When a lawyer takes funds to which he is not entitled, even under whether it is the premature taking of a fee or taking of an excessive fee that the client hasn't agreed to, those cases also are analyzed as if they were misappropriation cases.
So if there's a dispute over a fee, I just want to make sure I understand all these different cases. that are out there. If there is a dispute over a fee, a lawyer has a responsibility to put the amount of money into an escrow account.
The disputed funds are required to be held in escrow pending the resolution of that dispute.
And if a
yes.
lawyer fails to do that and takes any portion of those fees that are in dispute and puts them into his account, his personal account, takes any portion of the fee, he could be disbarred.
Yes.
That
And
means that even if there's no question that the lawyer is owed some fee,
the undisputed,
some fee.
the undisputed
No,
portion of the
some fee. It's not
Okay.
undisputed. Some fee. Some fee. And as we know, in some cases, it can take 5, 6, 7 years before these cases get to trial in the Superior Court or elsewhere. And that for that period of time, the lawyer, the client can simply say, even though the client has got a contingency fee agreement, because in the Von Wood case, there was a contingency fee agreement, so there was no question that he was entitled to 1/3 of something. The question was the payout schedule. Even though, for example, there's a dispute, you're saying if he had kept any amount of that fee?
No. What I'm saying and what the rule requires is that the disputed portion of the fee be put into an
But
escrow.
sometimes one doesn't know what the disputed
Well,
portion of the fee is. I'm asking you if there is a dispute over the fee and there's no undisputed portion.
Then all of it
even
has to be
though-
held in escrow.
Even though even the client agrees that some fee is owed. The client hasn't said, yes, I've agreed that it's $1,500 or $15,000 or $150,000.
Well, it seems to me that under those circumstances, the lawyer could try to negotiate with the client concerning what is not in dispute. If the client is willing to pay some amount of money as a fee, that could be agreed upon, and the lawyer is entitled to take that. But pending resolution of the dispute over the rest of the money, the lawyer has to keep that in the IOLTA
And
account.
Mr. Geller, what's the case that is closest, not the rule, what's the case that says if a lawyer keeps a fee in circumstances in which the lawyer believes the fee is due to him, and subsequently turns out that's incorrect, that he should be disbarred?
Well, there are two cases that I cited in my brief. I think one of them is Radigan, and there's another single justice opinion talking about what happens or what the penalty is for when a lawyer inappropriately takes money under the guise of fees to which the lawyer is not entitled. Let me just say that in the thank you. In the Stallworth case, there is still $1,000 missing that Mr. McBride has never accounted for and never repaid to the clients. In the Von Wood case, Mr. McBride took money that he wasn't entitled to. In the Felix case, there is a finding that Mr. Felix was harmed as a result of Mr. McBride's neglect in this case. Mr. McBride also did not return the money that Felix's brother had paid to him, even though he had done nothing on this case until after we filed a petition for discipline, and even then it was very late in paying it back. The pattern here is clear. Mr. McBride took the money first and dealt with the clients about it later, and we say that that disbarment is appropriate for all of the conduct. Thank you.
Thank you, Mr. Garrett.